The Supreme Court is expected to rule on several major cases with social implications in the coming weeks, including one on affirmative action in college admissions. Affirmative action is the practice of considering a prospective student's race as one of several factors in the admissions process. Other points of consideration include grades, test scores, application essays, and extracurricular activities. Affirmative action policies aim to increase diversity and address historical inequalities in education opportunities for underrepresented groups, such as Black, Hispanic, and Native American students. However, some critics argue that affirmative action is unfair and discriminatory to other applicants, especially Asian Americans, who claim they are held to higher standards and face lower chances of admission because of their race. The Supreme Court has upheld affirmative action in higher education several times since 1978, when it cited Harvard University as the model for using race as one of many factors in a holistic evaluation of applicants. But this time, Harvard itself is being challenged by a group called Students for Fair Admissions, which alleges that the university discriminates against Asian American applicants and violates federal anti-discrimination laws. A similar case is also pending against the University of North Carolina at Chapel Hill, a public institution that must comply with the 14th Amendment's guarantee of equal protection under the law. The outcome of these cases could have far-reaching implications for diversity on college campuses and in the workforce pipeline. If the Supreme Court strikes down affirmative action, many colleges may have to find alternative ways to achieve their diversity goals, such as using socioeconomic status or geographic location as proxies for race. Some states, such as California and Texas, have already banned race-based admissions and implemented other strategies, such as guaranteeing admission to top-performing high school students or increasing outreach and financial aid to low-income students. However, some experts warn that these alternatives are not as effective as affirmative action in creating a diverse and inclusive learning environment. They say that affirmative action helps colleges take steps toward greater equity in admissions and provides educational benefits for all students, such as exposure to different perspectives, enhanced critical thinking skills, and better preparation for a global society. They also say that affirmative action helps address the persistent racial gaps in access to quality education, which are rooted in historical and systemic factors such as segregation, discrimination, and underfunding of schools serving students of color. The Supreme Court's decision on affirmative action is expected by June 2023. Until then, many colleges and universities will continue to use race as one of many factors in their admissions process, while others will await the court's guidance on how to balance their diversity goals with their legal obligations. In this section, we will discuss how the Supreme Court could change affirmative action and student debt policies by reviewing a case that challenges Harvard University's admission program. Affirmative action is a policy that gives preference to minority groups in education and employment to promote diversity and address historical discrimination. The case before the court, Students for Fair Admissions v. Harvard, contends that Harvard's program violates the Equal Protection Clause of the 14th Amendment and discriminates against Asian American applicants. The case was brought by Students for Fair Admissions, an organization founded by legal activist Edward Blum, who has been fighting against what he sees as racial preferences in school admissions and other areas for decades. The plaintiffs argue that Harvard uses race as a determinative factor, not as one of many factors, in evaluating applicants. They claim that Harvard has a quota system that artificially caps the number of Asian American students and favors less qualified Black and Hispanic students. They also allege that Harvard does not explore or develop race-neutral alternatives to achieve diversity, such as using socioeconomic status or geographic location. Harvard denies these allegations and defends its admission program as consistent with the Supreme Court's precedents that allowed the use of race as a plus factor in a holistic review of each applicant. Harvard says that its program is modeled after the one that Justice Lewis Powell cited as an example in the landmark 1978 case Bakke v. Regents of the University of California. Harvard argues that its program seeks to enroll a diverse class that reflects the nation's pluralistic society and enhances the educational experience of all students. Harvard also asserts that it considers race only when necessary and that eliminating it would significantly reduce the representation of Black and Hispanic students on campus. The Supreme Court agreed to hear the case in June 2021, after the lower courts ruled in favor of Harvard. The oral arguments are scheduled for October 31, 2022, which is Halloween. Some observers note that this could be a symbolic date for a case that could end affirmative action in higher education as we know it. The court's decision could have far-reaching implications for hundreds of colleges and universities that use race-conscious admission policies, as well as for other areas where affirmative action is practiced, such as employment. The court's decision could also affect student debt policies, as some studies have shown that affirmative action helps reduce racial disparities in college completion and earnings. In summary, this section has explained how the Supreme Court could change affirmative action and student debt policies by reviewing a case that challenges Harvard University's admission program. The case involves a clash between two competing visions of equality, one that seeks to remedy past and present discrimination by fostering diversity and inclusion, and one that strives to achieve a colorblind society by eliminating racial considerations altogether. One of the most important issues that the Supreme Court will address this term is the fate of millions of student loan borrowers who are struggling to repay their debt. The court will also decide whether student loan borrowers can discharge their debt in bankruptcy, which is currently very difficult to do. The case involves a former law student who owes over $200,000 in federal and private loans and argues that his debt imposes an undue hardship on him.